But I don't have to agree to anything, right?
You don't have to agree to anything. By doing this mediation today, you can still go to court and still have a trial over all the same issues. The problem is, given the case history, given all the facts that we have to work with, there's a likelihood that, that will take place, that they will forever cut you off from your child. But this way, by coming to mediation, we have a chance to talk about things. We have a chance to make an agreement which would be written up as a contract, which would be enforceable in a court of law.
Just take a seat wherever you're comfortable.
In the past, most child neglect and abuse cases have been managed by social service departments and adjudicated by the courts, with legal counsel representing the interest of all the parties. This adversarial process has not always best served the complex needs of families in crisis. Plus, it takes a great deal of time for courts to sort out cases that do not lend themselves to simple solutions. Some jurisdictions are trying various methods of alternate dispute resolution. One of the most successful of these is mediation.
And now what's happened is that mediation has become a part of our court. It wasn't before, it is now. And what I mean by that is that the parties, all of the attorneys and the social workers and the judicial officers, we all look upon it as an extension of what we do in the courtroom. And we recognize that it can resolve problems that the court cannot resolve. It can resolve those court issues better than the court can resolve them. It can come up with more lasting results, that is, resolutions in which everybody buys into the result.
All the professionals are totally overwhelmed with cases. They don't talk to each other unless they're forced to do it, and then usually it's 5 minutes out in the hallway before they go into court. This is an opportunity for everybody involved to hear everything at the same time, to hear information that some of them have never heard before. Some attorneys from their own clients have never heard what they're hearing in the mediation. It makes all the difference.
One of the real advantages of mediation is that the people involved have the opportunity to create a custom solution that the court may not be able to do. The court has a certain list of remedies that it can order, but beyond that it can't go very far. The people at the table, however, have the opportunity to choose any solution that they think. For example, a relative may offer to pay for things or do things that a court wouldn't have the authority to order them to do, but they might voluntarily do. By signing the agreement and the court entering the agreement, they're now bound to do it.
But also being able to balance the powers at the table. And that's especially true in dependency, where you come in, where the parents are up against the wall. They're in a very defensive posture, and everything they've already been through has been aimed at them, and they're the weakest at the table. So I'm very aware of making them feel more comfortable in a very uncomfortable situation.
Everyone's going to have a chance to talk about your concern, each of your concerns for Jonte. And we're going to ask you to try not to interrupt when someone else is talking. And we know that's hard. That can be really hard.
What we have found time after time is that people have been through all attempts at settlement, are set for trial, think they have all the current case information. We walk in the door, begin talking, and they don't. And the information they don't have is the information they need that will help them resolve the case.
And Nina and my understanding is that Jonte has been in a permanent plan for some time, and it's been long-term placement. And there's been a recommendation from the department that that permanent plan change to adoption. And that's got to be one of the most difficult things that a parent would ever have to be faced to have to talk about. But that's our understanding of what we're here to discuss.
Dependency mediation focuses on fairness, privacy, self-determination, as well as the best interest of all parties, especially the vulnerable children who are the focus of the case.
And one thing you did say I agree with 100% is that Jonte do need you in his life, but he's been in my home long enough now that he needs me also, and my family, who he's grown up with.
Children are served well in this process. There's more likely to be a solution earlier. and so service is more likely to be in place for the children as well as for the families. Families are given an opportunity to be a part of the process. Instead of parents being viewed in court more as a part of the problem, here in mediation they have an opportunity to be part of the solution as well. There tends to be a greater, I believe, likelihood that if reunification is possible, it can happen, because by getting services in place sooner, there's more chance for families to really work to solve the problems that brought them to the attention of child protection in the first place. And if permanence is something that needs to be achieved for the child outside of the family, that also is more likely to happen more quickly. So that's also a very positive result.
The really positive things about it are that it is a process that allows the parties to come up with their own solution. The mediators are neutral, they're third parties, they're not decision makers. They're there to assist the parties in reaching a solution that they're comfortable with and that they can live with long term.
I mean, it's probably the perfect concurrent planning case because,
That's right.
you know, because, I mean, it brings everything into play
And-
because she's the young and the short time.
And one of the uncertainties is
I was very skeptical about mediation when it was first proposed. I think the other attorneys in my office were, as well as the attorneys in the other offices associated with the dependency court. It was something that was very new. I think as lawyers there's always a certain sense and fear that maybe you're going to lose some control, and that is something that I think you work very hard to have in a trial process, to be able to make the case go the way that you want it to. And in mediation it doesn't work that way. There were a number of discussions about what format the mediations would take, whether lawyers would even be involved or not, and there are different models for it.
A wide variety of mediation models are used in different jurisdictions. Sometimes the mediations are voluntary, other times court-ordered. Sometimes the mediation begins early in a case, when a social service agency calls for mediation at the case planning stage. But it can be called at any time during the life of a case, including the mediation of highly contested situations, such as deciding on termination of parental rights.
So what would your comments be at this stage? What would you like to tell everybody?
Actually, I am happy that everyone is here. This is the first time that I feel that I've been heard. I've been in the background for so long, and I feel that, you know, I mean, she is so very important to me, and this is a very important decision, so I'm happy you all came together. And it seems like we are all talking about the most important thing and what happens to Amber long term.
Is we tried to talk about the history of the case, talk about the facts of the case, and then talk about the perspectives that each player has regarding the facts of the case. And then you move on and try to develop themes around the facts. Because if in mediation you can define the themes accurately, then you can start to define solutions to the themes.
And we can look at a process of certifying them, and that means that would be a step that would allow Amber to be placed with them as in a foster home.
We don't get the cases that are going to settle somewhere else. We get the cases that are on their way or set for hearing or trial, for the most part. So in mediation, we tend to get the most difficult cases. And even in the most difficult cases, whatever the issue is that's been referred resolves most of the time.
Mediations have been used for everything from petty family disputes through the termination of parental rights. Cases frequently include violent domestic abuse, sexual abuse, and other complex matters that once were believed to be beyond the scope of peaceful discussions. Various jurisdictions have developed standards and practices for what types of cases they will refer for mediation, with some selecting only those they feel have the best chance of success. Others send all their contested cases to mediation and are pleased with the high rate of resolution.
I asked Steve Barron to come over, and naturally I picked 4 sexual abuse cases, the toughest, most severe cases that we get. And he resolved, through a mediation process, usually taking 2 to 3 hours, he resolved all 4 of those cases. This is over a 2 or 3 week period in one session each. Safety of the child was never compromised. The ability of the family to talk out the problems was the reason for the success. And all the parties in the process and of course in dependency court there are many parties who are in mediation, came away believing that, my goodness, if we could safely resolve these issues, well, we can do anything.
One consideration that is an important consideration is whether the parties themselves, the parents, or other family members, or anyone involved, would be able to effectively and meaningfully participate in mediation. So issues of capacity or competence of the parties may come into question. Certainly where there are concerns with domestic violence, substance abuse, mental illness, there may be some people who may have difficulty participating in a meaningful way in this process. Certainly there are some cases, such as child sexual abuse, where one would have serious concerns about the children ever participating in a mediation where they might be exposed to the perpetrator. There may also be a concurrent criminal charge pending. Some of those cases will be more difficult to mediate, since there will be concerns about whether there would be a consequence of what happens in the child protection case that would impact the criminal case, though sometimes, in fact, that may be a good thing to do, and it really has to be looked at on an individual basis.
My name is Claudia Grinnell, and I'm one of the co-mediators, and this is
Alana Maddox, I'm your other mediator.
And a little bit about the mediation process. We're not
Some mediations only have one mediator, but not infrequently a team of two handles a case. Mediators can be mental health professionals, attorneys, or people with other specialized training, and most know the dependency laws in their communities.
In our program, we picked licensed therapists. In other programs, they may be attorneys who are experienced with family and juvenile court. They may be ex-child advocates. They may be probation officers. They may be contract mediators or therapists. Our model is we have a male-female co-mediation team, which we think is a real advantage because some clients are more comfortable talking with men than women. And other clients are more comfortable talking with women than men, and we'll disclose things to a person of a certain gender they won't feel comfortable disclosing to another.
We want you to feel free.
Well, what if she lies, and what do I do about that?
I hear that you have a concern about what's going to be said today.
Yeah. She's going to say not very nice things about me.
What we would like is for you to be able to... I would like you to be able to say anything that you want to say today that will be helpful to the process. And we're going to set a few ground rules in our time together. And one is we're going to ask that each of you let the other person speak uninterrupted.
Some venting is important for some people. And you know, sometimes the hidden agenda is not the issue on the table, not the legal issue. It's the emotional issue. They want I'm sorry. Or they want to be able to explain why I did something. There's so much more psychological and emotional components to this than just the legal issues that are never allowed to be discussed in the courtroom, for instance. If you don't have emotion for some of these issues, like visitation, for an example, enforcing visitation, that doesn't get discussed in front of a judge, but it gets discussed all the time in mediation.
But people are talking like, I'm just going to be able to visit. You don't let me visit. You've canceled visits on me. I mean, you know, this is all nice pie in the sky stuff, but this isn't what's happening. What guarantees do I have that I'll still visit? You don't let me visit some of the time. It's always a problem.
Your fear is based on some past history of visits being canceled.
The role of the mediator includes assisting the parties in identifying the issues, fostering joint problem solving, and exploring settlement issues. This neutral third party encourages and facilitates the process without prescribing what the solution should be. The principles of mediation are based on communication, negotiation, facilitation, and problem solving. Mediation focuses on the needs and interests of the participants, fairness, procedural flexibility, privacy and confidentiality, full disclosure, and self-determination.
The idea has been discussed that the best interests of Amber might be served by her going long-term into the home of a family friend of Gloria's.
You know, we had a case recently, I think you probably observed a case, where a dad was brought in from jail to participate in mediation. And everybody, I don't know what they thought he wanted. visitation, contact, a family placement, and he realized that wasn't best for the child. But the kind of setting where people are allowed to talk, to express some feeling, to vent, to be heard, really truly heard and listened to, produces change.
Gary has suggested that you will be supportive of what seems to be in the best interest of your daughter, hard as it is for you.
Yes, sir. So all I want is what's best for my daughter. I want her to have a chance at a good life.
You want her to have a chance to
Have a good life. To have a good life.
Depending on the community, participants usually include one or both parents, the minor child, caseworker, attorney for the parent, attorney for the minor, attorney for the Department of Social Service, guardian ad litem, or CASA volunteer, as well as others like kinship care providers, foster parents, or others involved in the case. Sometimes the court enters an order of those who must appear at the mediation, stating any parties or participants who are prohibited from attending the mediation and naming additional participants who may be included by court order or mutual agreement of all parties.
We have minors attend if they're old enough and if the issues warrant their being involved, as long as they're not going to be done any more harm by being involved in the process. We often have caregivers involved. We sometimes have therapists who attend or who are on standby on the phone.
Sometimes it's an emotional support system's needed. Sometimes you need an interpreter. Whether the person's deaf or whether they speak Spanish or, there are many people that attend mediation who are not party to the case.
This is a confidential process. Anything that you say here will not be repeated by us outside of this room.
What about her? Is she going to go tell the people where she works? I mean, what about if she tells her something and it's...
Well, our cases are confidential too. It's not a public record. What you tell me goes between me and my supervisor, and that's about it.
Confidentiality relates to the full and open disclosure necessary for the mediation process to be successful. The mediator usually obtains the consent of the participants prior to releasing any information to others and agrees to maintain confidentiality outside of the mediation process. The mediator informs the parties of any limitations on confidentiality, such as mandated reporting of any new allegations of abuse that come out during the mediation session.
We always say that the exceptions to the rule of confidentiality are if we hear threats to harm another person, threats or instances of child abuse or spouse abuse, and we let them know that by law we are mandated to report those.
Now, there's tremendous variability around the country as to what is confidential and what is not, but it's important that the parties know that they do have greater freedom to talk in mediation than they would in court. Oftentimes, it's the mediator's obligation to make sure that the parties understand what the limitations of confidentiality are and to what extent confidentiality exists. And oftentimes, mediators may invite everyone involved to sign a confidentiality agreement where they're agreeing, basically, to what the protections will be for the privacy of this mediation.
Maya, she's recovering from drugs, and she's doing a good job. She's in AA meetings at least twice a week. She's very patient and loving with the children, and she has a job in the house, and she also has a daycare for the children to attend while she works.
And one of the problems with child welfare is you want to be a social worker and do good things for the family, but you become an adversary as soon as you have to write those negative reports and take the stand and say awful things about the parents. And I think a large number of the child welfare workers have realized that there's a lot more social work in mediation than there is in a trial.
I never felt like you wanted me to be around.
Oh, no. I always wish that you would come around more because, John Tay, I know he would love to see you when we're sitting down for Thanksgiving dinner. I know he would love to see you at the table, And I would have loved to see that look in his eyes to see you sitting there.
Are you real? Really?
Yes, that's never been the door is always open for you to come. You're part of the family just like John Tay is.
Another positive that mediation has to offer is that it can clear up some misunderstandings between people. For instance, in dependency, sometimes the foster parents haven't met the parents before. And when they meet at the table, they actually don't envision a monster anymore. They have a human being in front of them who has feelings. And they can actually relate to each other through the child. Because normally they both love the children or the child. So that's where they connect.
And that we are in agreement here that we would try to certify that family friend as a foster family, that we will then move to get an adoption study, is that what you call it? An adoption study is started. That the
If an agreement is reached as to all or part of any matter or issue, including legal or factual issues to be determined by the court, the agreement is immediately reduced to writing, signed by the attending parties, and submitted to the court with copies to all parties and counsel.
In many parts of the country, the court is faced with probably three choices. They can accept the agreement as is, they can reject the agreement and either send the parties back to mediation if they had referred them in the first place, or proceed to trial. Or lastly, in some areas, the court might seek to change the agreement, but only with the consent of the parties, since it wouldn't be appropriate for the court to change an agreement unless the parties had also agreed to those changes.
This aunt is very committed to this child. She has had her since she was placed in protective custody. This is the aunt who made the report. This is the aunt who was with the mom of her niece when the child was born and helped out.
When they settled through mediation, as opposed to being settled either through a settlement conference or an informal meeting of the attorneys and the worker, or through court, if they resolved in mediation at that stage, there tended to be a significantly fewer number of contested hearings over the next couple of years.
But it saves all the trial time. For instance, the case that was set for a 5-day trial settled in 3 hours of everybody's participation. Just the attorneys, not the courtroom, not the bailiff, not the clerk, settled it there. And that's what happens 70% of the time.
Which is
And I haven't
plus.
any problem with the plan that you've worked out. That's fine. It sounds like a perfect way of handling a very imperfect situation. The only
When we started mediation, I think I was telling you downstairs, I was very against it. I think a lot of why I was against it is because I didn't understand it. And I felt like it was taking away a big part of what my job was. And so it was very difficult for me to buy into the mediation concept. Then I started to find out, when I did send things to mediation, that the solutions that they came back with were very similar to the ones that I managed to kind of get people to buy into. But the real people, the parents, the children, the foster parents, the social workers, they were involved in the process. And so they had a hand in coming up with the solution. And their solutions were every bit as good as mine, and they worked better because they were the ones that solved their own problems.
And this was a huge change in the court system here, and it is in any court system. And parents' attorneys in particular are very, very concerned about how mediation is going to affect their clients' rights and how confidentiality is going to work. How can they trust confidentiality when they don't know who these mediators are? So there's a tremendous amount of trust building with the players in the court.
An important part of successful implementation of a program is bringing together the key stakeholders, bringing together the agency in that county or state that serves to protect children, bringing together judges and court personnel, bringing together the attorneys that represent the agency for children, guardian ad litem, court-appointed special advocates, defense counsel, and others that are involved in child protection, and letting them begin to really shape their own program. Child protection in many ways is very local, and so solutions need to be found within the resources and capabilities and interests in a given community. The next step in putting together the program after that is really to find and identify mediators in the community, to provide specialized training for them that addresses the needs that they would have as mediators in child protection cases, training in mediating multi-party disputes, training in the dynamics of abuse and neglect, training in the law that is involved in child protection, training in the kinds of problems that the parents have in these cases, and also training in what kind of resources may be available for these parents as well.
So it sounds like the two of you may be able to work out a schedule that's going to give both of you some quality time with the children. It's going to be good for both of you and for the children as well.
And then when they get in school, I could keep them after school and give them their supper.
You all coming up with the decisions that are going to affect your life is definitely preferred.
Maybe you and I can do this together.
I believe it can happen because I know you love Jonte, and I know you want to be a part of his life, and I know you don't want to disrupt anything that's already happening. And I'm willing to work with you to see that it happens, that you could be a part of him, and he won't be disturbed in the process.
I mean, according to the plan that you folks have worked out, the longer Amber's with them, before we get to the point of choosing an adoptive home, the more likely it is
she'll stay.
You know, and I'm going to make an order that she not be removed from the home once she's placed. I'm going to make a placement.
When parents and child welfare workers and attorneys can come together, knowing more than we could ever know, to figure out a resolution for a particular child, it's more likely to be a good resolution. I mean, there we are, sitting on the bench, dealing with all the rules of evidence and procedure and what you get to hear and what you don't get to hear as a judge, and then we're making a decision that is a life decision for a child.
There are many advantages to mediation. One is cost. In most cases, you can settle a case for a fraction of the cost it would take to litigate the matter. We don't have discovery, we don't have, a lot of hearings, we don't have a lot of paperwork and so on that is costly. And certainly going to court is costly. If you need witnesses and you have to pay people to be there, it can be extremely costly.
I often say mediation is hard-headed and soft-hearted. It's not a soft-headed process. You've got to deal with realities and facts and themes, and you've got to have actual solutions that protect children and guarantee that these things will never happen again. And that's the purpose of mediation.
The agreement is not the goal. The process is the goal. Because mediators can reach an agreement or not reach an agreement, and yet the parties have heard each other. Sometimes they've heard each other through another person's voice, because part of the mediation process is continually paraphrasing, and so they've heard it in a new way. And so there are many types of successes in mediation, not just an agreement.
This is not a pipe dream. This is not something that's theoretical. This is not something that we're just dreaming about and we hope it can be done. We were able to say this can be done because we're doing it, and so we're not asking of people across this state to do anything that we're not doing, and we're not asking them to do something that's just a dream.
Well, the bottom line is mediation in dependency cases saves judicial time, empowers the parties, and fosters better outcomes for the children. That's what it's about.